Hey everyone, welcome back to the Texas Business Court Insider. I'm Rafe Schaefer. I'm here with my colleague, Kate Ergenbright.
Today we're going to be covering a new opinion from the Business Court's 11th Division, Energy Founders Fund versus Daskovich, which was issued by Judge Brian Stagner sitting by assignment. Now this opinion involves a director's advancement rights. Specifically, whether an LLC agreement's advancement provision required a company to pay the legal fees of its director. Now, this is an issue that comes up a lot in Delaware Chancery Court, but to date, there's very little Texas law on the topic.
So here's some background on the dispute. Gage Western is a Texas LLC, and Philip Daskovich was both a member in that LLC and a director. There was a dispute that arose out of a drag-along sale where the majority owners approved the transaction, but Daskovich voted against it. He brought suit, litigation followed over whether the entity and the majority had complied with the various transfer obligations and whether Daskovich had complied with his transfer obligations in a drag-along sale. Daskovich then moved to compel Gage Western to advance his defense costs, and that's really what we're talking about here today. Kate, in looking at the advancement issues, what were the key questions the court had to work through?
So, Rafe, there were three questions that the court worked through in its opinion. The first is which LLC agreement governed the advancement rights at issue? The one that was in effect when the underlying conduct at issue in the proceeding that Daskovich was trying to get advancement rights had actually occurred, or an amended version of the LLC agreement that was adopted later when litigation was actually filed. The second question, whether the director, Daskovich, had satisfied or was excused from satisfying the LLC agreement's condition precedent to invoking his advancement rights. And third, whether the claims that were filed against the director were brought by reason of his service as a director, or if the claims had something to do with something else entirely. Now, before we get into those questions, Rafe, what analytical framework does the court apply?
Well, the court started from the idea that LLCs in Texas are creatures of contract, right? You can set up an LLC really in any way that you want or that you contractually agree to, as long as it's not contrary to some very specific points of the Texas Biz Org Code. And so in Texas, advancement rights for an LLC are purely contractual. And the Business Organization Code permits but does not require LLCs to provide for advancement rights. And companies have a lot of flexibility in how they provide or don't provide those rights. So the court's initial task was just to apply straightforward contract interpretation principles, giving effect to the parties' expressed intent as reflected in the LLC agreement. To do that, the court adopted what's called the 8 corners approach, or the 8 corners rule, which is probably familiar to a lot of practitioners in Texas who have dealt with insurance or indemnity. It's the same inquiry. Advancement proceedings are summary in nature. They're based on the allegations. So the 8 corners compares the 4 corners of the underlying allegations with the 4 corners of the advancement right, without wading into a fact-intensive, merits question of, does the underlying case have merit?
It's also worth noting, Rafe, here at the outset, that the court leans heavily on Delaware law in adopting this framework, as Delaware has a far more developed body of case law in this area. So now let's turn back to those 3 questions I went over a few moments ago. Rafe, for the first question, how did the court determine which LLC agreement controlled here?
This was an interesting question. The way you've framed the question seems like it's not a very complicated one. But originally, there was an LLC agreement that was entered into when Daskovich became a member and a board member. On the same date that suit was filed, Gage Western actually amended the LLC agreement and adopted a 4th amended company agreement, replacing the 3rd amended company agreement that Daskovich had originally become a member under. The 4th amended LLC agreement removed the advancement right entirely. It removed advancement, it removed indemnification from the company agreement, And the company, Gage Western, then said, well, we've removed the right to advancement, therefore Daskovich doesn't receive advancement. The court said that doesn't work. The court said a director's right to advancement arises from the agreement in effect when he or she agrees to perform the director's services. Kate, what was the court's reasoning in entering into that kind of look-back approach?
Yeah, so Rafe, looking to Delaware law, the court reasoned that the advancement rights are part of the bargain when an individual agrees to serve as a director. Advancement is part of what the company offers a director in exchange for those director services. And once those director services are performed, the advancement rights, if they are provided in a company agreement, vest and cannot be later withdrawn by amending them out of the company agreement like Gage Western tried to do. Now, Rafe, what about the second question? What did the court say about conditions precedent?
Well, the court initially said, again, advancement provisions are creatures of contract, and so if you've got a condition precedent, those conditions are enforceable. The third company agreement, the one in effect when Daskovich entered into the bargain to become a director, required two things. First, the director had to sign a written undertaking promising to repay any advancement if, upon a later determined factual proceeding, it was determined that advancement wasn't owed. Daskovich had to agree, I will pay the money back. Second, the board had to determine that the director was financially capable of making that payment. So the director has to say, I'll pay you back, and the board has to say, we independently think the director has the ability to do that. Daskovich provided the written undertaking, but the board took the position that the fourth amended company agreement applied. There was no advancement right, and there was no indemnification right, and didn't provide or make any of the determinations required under the LLC agreement. Gage Western then argued that the board's failure to determine Daskovich was capable of financially repaying prevented him from receiving advancement. The court once again said, not so fast, my friend. It's a fundamental rule of contract law that you can't procure your own failure of condition precedent to escape liability. And so by eliminating the board determination, and in fact, I think the fourth amended LLC agreement eliminated the board entirely, Gage Western had prevented the determination from being made in the first place. The court said you can't, again, procure your own failure to perform. And the director won on those first two key issues. Kate, what was the determination on the third issue?
So the third and final question that the court considered was whether that the claims filed in the underlying case against the director were filed by reason of the fact that he actually was a director of Gage Western. So when the court applied the 8 corners framework that we've discussed, it found that the claims pled didn't actually target the director's conduct as a director. Those claims arose from Daskovich's alleged refusal as a member of Gage Western to transfer his ownership units in this drag-along sale. The court found that the petition involved shareholder rights and contractual obligations, but not fiduciary conduct of Daskovich as a director of Gage Western. So, Rafe, what are some key takeaways here for practitioners?
Well, I think we've said it about 5 times now. Advancement rights and LLCs are creatures of contract. And so the language you implement into your LLC agreement and your advancement provision, it matters. And it matters at the time that provision is drafted. There are no takebacks. And so if you're going to adopt the by reason of the fact that standard, like in Gage Western's LLC agreement, which has a whole body of law in Delaware, there are other types of standards arising out of, related to all of those, different contractual choices at the time of contracting weave into whether or not there's going to be advancement in any given case. And once you promise advancement, there's no taking it away unless you've adopted a narrow causation or causality such that the 8 corners test isn't going to find advancement. Kate, what else should the practitioner think about?
Yeah, Rafe. So if you represent a director who may face litigation, think carefully about the claims as they are actually pled and how they're framed by the plaintiff, because that framing, how the plaintiff has pled their claim, really drives the advancement analysis as we have discussed here. So under this 8 corners approach, considering how a court may view the claims as pled should really factor into your analysis as to whether advancement rights, you're really likely to get them and if it's worth going down the path. Thanks for watching the Texas Business Court Insider. Be sure to hit like and subscribe to get notified of our new videos, and check out our Texas Business Court Insider Hub via the link below to see our other videos and thought leadership.